Thank you, Pietro. And in fact, tomorrow we're going to have an informal meeting at Confitarma involving also the Ministry of Transport. And one of the things on the agenda will be exactly that we have to get on and ratify the LLMC. Amongst these things, tomorrow, which we are going to discuss, there are also very practical issues in relation to the certifications which ships needs to have on board because of the enactment of both the Insurance Directive and of the forthcoming 31st of December of this year of the the PLR, the passengers limitation responsibility for owners of passenger vessels. Both of the directives require certification in a similar way as the Bunker Convention has done, as the CLC Convention has done, and those will require the liability insurers of the vessels to provide certification of the existence of insurance to the flag state, for the flag state to be in a position to issue their own certificate as required. That will involve a few problems about which we are going to discuss in a moment, but prior to that, talking of the practical problems of things having been done in a rush, we wanted to touch upon the directive, the Insurance Directive, which came into force in August this year, which basically is just requiring, as Professor Berlingeri was mentioning, that the vessels are insured and that there is a proper evidence of insurance on board. The directive itself mentioned the type of certification which would have been, or of evidence which would have been complying with the requirements, and that was a certificate of entry in, for example, an international pool club. In August, obviously these things always happen in August, the thing started, and there was a complete confusion at level of Italian port authorities, for example, on what would have been a certification or a policy which would have been complying with the demand. The thing is written in the directive. It is a certificate from a club in the form in which the clubs are issuing these certifications. Despite that, we have seen for weeks and weeks port authorities asking for the most strange things. They wanted to see limits of liability in there. They wanted confirmation that the thing was worldwide and not there was no geographical limitation. They wanted all sorts of things which were absolutely unnecessary. They were specifically mentioned in the directive. Despite that, we had to fight for almost a month, even getting a circular from the Ministry of Transport trying to clarify the scope of the directive. But still a week ago, we had a case of one port authority which came up with another question, totally unnecessary, which caused delay, a 2 days delay, because it was necessary for them to understand that that certificate which was on board was exactly what was required by the directive, nothing else, but it took time to get them to accept it. On this issue, on this practical issue, I'm very pleased that we have David Baker here. David is from the International Group of P&I Clubs. We always hear about this International Group of P&I Clubs, and we think it's sort of an entity somewhere. No, there is real people behind it. David is one of them. They rarely appear in public in occasions like this one, so I'm very pleased that they accepted to be here. And he will just try to, if we can, make simple and try to deliver a message, which we are going to discuss again tomorrow with Confitarma, CONSAP, and the Ministry of Transport, on what is required to satisfy the Insurance Directive. David.
This is a fairly short speaking slot, so I'm going to be working on the basis that most are actually aware of the key principles of the Insurance Directive at least. Some have already been touched on, but I'll be touching on the key ones as we go along in the next 10 minutes or so. Firstly, a few general observations from an international group perspective on the Insurance Directive itself. Firstly, the directive text that we have in front of us now, as was agreed in April 2009, is very different to the original Commission proposal that was tabled in November 2005. The Commission proposal that was tabled then contained provisions on the rights of direct action against insurers, flag state certification, and an amended test for breaking the owner's right to limit liability based on gross misconduct of the assured. Thankfully, those difficult provisions, those problem provisions were taken out of the directive text, and they're not contained in the text that we have today. Well, some problems on implementation of the directive have been mentioned so far, but quite frankly, implementation of this directive should not be difficult or complicated. It is a fairly straightforward text. It should be easy for states to give effect to it. It's certainly not complicated when you compare it with, for example, the EU Passenger Liability Regulation, which also makes up one of the dossiers of the third maritime safety package. Certainly from the perspective of the international group clubs, we have seen no significant problems for the clubs or their members since implementation of the directive, the effective date anyway, the 1st of January 2012. We've had some port state control queries, as Federico has mentioned, but nothing too significant. We think that's just port state control officers being port state control officers. And fourthly, not all EU member states have yet given effect to the directive, despite the effective implementation date of the 1st of January this year. Nearly all have done so, but one or two are still to fully give effect to the directive. We would expect that to change in the next few months. Well, perhaps a few reasons just to explain why we are where we are. We, as the International Group Secretariat, have liaised, directly or indirectly, with every single EU member state on implementation of the directive, in order to try to ensure a smooth implementation for ship owners, for states, and for clubs. Now, the liaison with the administration here in Italy has been done by Confitama, for which many thanks to them. But generally speaking, we as a Secretariat have had to liaise with each state on a state-by-state basis, firstly to ascertain what it is they would require, and secondly to try to persuade them to accept group club issued certificates of entry as evidence of compliance, and I'll come on to that in a second. Secondly, most owners on EU registries already maintain third-party liability insurance cover anyway, so these new requirements shouldn't be too concerning. For example, the 2001 IMO Bunkers Convention has been in force in nearly all EU coastal member states for some time now, and owners have to abide by the insurance requirements under that convention, albeit that it applies to vessels excess 1000 GT, and here we're talking about vessels excess 300 GT. Thirdly, the key provisions of the directive actually reflect existing IMO guidelines that were agreed by the IMO way back in 1999. The IMO guidelines on ship owners' responsibilities in respect of maritime claims, as contained in IMO Assembly Resolution 898. The key provisions of the Insurance Directive are similar, if not identical, to those guidelines that have been in place for a number of years now. It was the intention of states to make those guidelines mandatory, and that's more or less what they've done with the Insurance Directive. And if you look at the definition of insurance, that's on the screen, that's contained in the directive and the guidelines, it's almost identical. Insurance that ship owners have to have in place, being insurance of the type currently provided by members of the International Group of P&I clubs. So what is the current position of EU member states? Well, it should be obvious, really, given the definition of insurance. All EU member states that are currently giving effect to the directive accept international group club cover, and as a result, as Federico mentioned earlier, they accept international group club issued certificates of entry as evidence of compliance with the directive for port state control purposes. No new certificates are required. There are no new blue cards, no COFAs, no financial guarantees that are necessary. It is simply certificates of entry in their current form. There's no need for any amendments to them at all, and that is the position of EU member states as it currently stands. What is the position with regards to non-international group P&I providers? Well, many flag states actually apply guidelines already for the purposes of accepting non-international group issued Bunker Convention blue cards. And it's probably the case that European Union member states are applying the same guidelines for accepting certificates issued by non-international group P&I providers as evidence of compliance with this particular directive. Those guidelines contained in IMO Circular number 3145. Have there been issues of debate with states? Well, there have been one or two. Nothing we would suggest that's been too significant. Does the scope of P&I cover all claims subject to limitation, as seems to be required by the directive? From our perspective, that question is actually irrelevant. What matters to us is what's happening on the ground, how states are applying the directive, and what they're requiring. And what they're requiring is IG Club issued certificates of entry for vessels entered in IG Clubs. That's all that matters. Does the directive apply to all seagoing vessels, seaborne craft of any type whatsoever, in the same manner as the Bunkers Convention, given that there's no definition of ship in the directive? The key provisions of the directive would suggest it applies to vessels engaged in maritime transportation only. If you look at the port state provisions in the directive, the fact that it requires insurance certificates to be in place, with IMO numbers on them, it would suggest that we're only talking about vessels engaged in maritime transportation. And is the non-ratification of the 1996 LLMC protocol by some EU member states an issue, given that vessels are supposed to have insurance cover in place up to their limit of liability under the 96 protocol? Quite frankly, it's not an issue as far as we're concerned. For the purposes of having insurance in place to meet the directive requirements, states can make the read across between the vessel's gross tonnage and the corresponding limit of liability under the 96 protocol, irrespective of whether the protocol is in force or not in that state. It really shouldn't matter. But in any event, for all international group club entered vessels, they have cover in place up to their limit of liability under the 96 protocol, at the very least. So it shouldn't be an issue for international group club entered vessels. Chair, it's been short and sweet, but in short, the message from our side is that this should be straightforward. It shouldn't be difficult. There haven't been any significant problems since the 1st of January. We don't envisage any significant problems going ahead. Thank you very much.